Dear students, today we will discuss an important case regarding the protection of tribal lands in India. The citation of the case is Samtha versus State of Andhra Pradesh and others, 1997, 8 SCC 191. The petitioner in the case is Samtha, an NGO working among tribal people in Andhra Pradesh, and the respondents are the State of Andhra Pradesh and others. The judgment was delivered on 11th July 1997. The bench of the judges consisted of Justice K. Ramaswamy, Justice S. Sagir Ahmed, and Justice G. B. Patnaik, and the judgment was delivered by Justice Ramaswamy. Now, these appeals are directed to resolve mutually inconsistent law laid by two division benches of Andhra Pradesh High Court. The appeals arise from writ petitions in which the division bench has held that the Andhra Pradesh Scheduled Area Land Transfer Regulation as amended by 1970 regulation and the Mining Act of 1957 do not prohibit grant of mining leases of government land in the scheduled area to non-tribals. The case was against the government of Andhra Pradesh for leasing out tribal lands to private mining companies in the scheduled areas. It led to an historic judgment in July 1997. The relevant findings of the Apex Court can be summarized as: 1. The Supreme Court declared that the government is also a person and that all lands leased to private mining companies in the scheduled areas are null and void. 2. Transfer of land in the scheduled area by way of lease to non-tribals, corporation aggregate, etc. stands prohibited. 3. Transfer of mining lease to non-tribals, company, corporation aggregate or partnership firm, etc. is unconstitutional, void and inoperative. 4. The court urged government to take a policy decision for a consistent scheme throughout the country in respect of tribal lands. 5. Every Gram Sabha shall be competent to safeguard and preserve community resources. 6. Minerals to be exploited by tribals themselves, either individually or through cooperative societies with the financial assistance of the state. And finally, 7. At least 20% of the profits as permanent fund for development needs apart from reforestation and maintenance of ecology. Dear students, let us now see how the 5th schedule of the Constitution of India is fundamental to the Samtha judgment. The 5th schedule of Indian Constitution provides protection to the Adivasi, that is tribal people, living in the scheduled areas of 9 states in the country from alienation of their lands and natural resources to non-tribals. This constitutional safeguard is now under imminent threat of being amended to effect transfer of tribal lands to non-tribals and to corporates. This move has serious implications to the 80 million tribal population of this country, their very survival and culture. Let us now have a look at the socio-political background to Samtha case. The scheduled tribes or the aborigines are a backward section of Indian population. They still observe their primitive ways of living and inhabit the most inaccessible forests of the country. They constitute more than 7.5% of the population. This would mean a population of 8 crores or more are tribal people in India. This is more than the population of many European nations. They need special provisions to safeguard their socio-economic interests. Our Constitution enjoins facilities and opportunities for development of tribal economic and educational standards and safeguard them from exploitation. Now, it is in this context we study the 5th schedule of our Constitution, providing special protection to the tribal peoples from alienation of their land to outsiders, including mining requirements of the country. Let us have a look at the constitutional provision regarding administration of tribal lands. Article 244(1) of Indian Constitution states, administration of scheduled areas and tribal areas. The provisions of the 5th schedule shall apply to the administration and control of the scheduled areas and scheduled tribes in any state other than the states of Assam, Meghalaya, Tripura and Mizoram. 5th schedule does not include provisions for the tribal peoples of Assam, Meghalaya, Tripura and Mizoram. The tribals of these areas are provided in the 6th schedule of the Constitution. Now, Part B of the 5th schedule provides for administration and control of scheduled areas and scheduled tribes. It states, there shall be a tribes advisory council in each state having scheduled areas therein, and there is provision for their representation in the legislative assemblies. Section 5(2) of the schedule reads, the governor may make regulations for the peace and good government of any area in a state which is for the time being a scheduled area. In particular, and without prejudice to the generality of the foregoing power, such regulations may prohibit or restrict the transfer of land by or among members of the scheduled tribes in such area, regulate the allotment of land to members of the scheduled tribes in such area, regulate the carrying on of business as money lenders by persons who lend money to members of the scheduled tribes in such area. All regulations made under this paragraph shall be submitted to forthwith to the President and, until assented by him or her, shall have no effect. Part C of the schedule provides the list of the scheduled areas. Under Section 6 of the schedule, the President of India may by order declare such areas as scheduled areas. Vast areas or districts in the states of Andhra Pradesh, Orissa, West Bengal, Bihar, Jharkhand, Chhattisgarh, Maharashtra, Gujarat, Himachal Pradesh and Rajasthan have predominantly high number of tribal population and are notified as scheduled areas. It will be good to have a political map of India in front of you to see the spread of tribal areas in India. Here you can see the districts within the 5th schedule: Visakhapatnam, East Godavari, West Godavari, Adilabad and Warangal in the state of Andhra Pradesh, Ranchi, Singhbhum, Palamu and Sandal Parganas in the state of Jharkhand, Dangs, Surat, Bharuch and Valsad in the state of Gujarat, Lahul, Spiti, Kinnaur and Chamba in the state of Himachal Pradesh, Jhabua, Mandla, Dindori, Barwani, Dhar, West Nimar, East Nimar, Ratlam, Betul, Sioni, Balaghat, Hoshangabad, Siddhi, Shadoi, Umaria, Shiopurant, Chhindwara, etc. in Madhya Pradesh, Sarguja, Korea, Jashpur, Kankar, Dantewada, Korba, Raigad, Bilaspur, Durg, Rajnandgaon, Raipur and Damtari in the state of Chhattisgarh, Thane, Nasik, Dhule, Jalgaon, Ahmednagar, Pune, Nanded, Amravati, Yavatmi, Gadchiroli and Chandrapur in Maharashtra, Mayurganj, Sundargarh, Koraput, Sambalpur, Keonjhar, Konmals, Ganjam, Kalhandi and Bilaspur in the state of Orissa, Banswara, Dungarpur, Udaipur, Chittorgarh and Sirohi in the state of Rajasthan. One thing we notice immediately is that these are also areas that are Naxalite or Maoist or extremist affected. Now, let us have a look at the background to the case. Samtha is an advocacy and social action group working in the southern state of Andhra Pradesh and has been fighting for the rights of tribal communities and for the protection of the environment in the Eastern Ghats region. In 1992, Samtha was involved in an apparently local dispute over tribal lands being leased out to private mining industries, while the government denied the people grant of title deeds. Little did it know at that point of time that the issue had global implications and was a direct impact of the liberalization process under the new economic policy. The people were forced to work as wage laborers in their own lands, where small private companies were extracting minerals like mica and limestone. The tribal community approached Samtha for regaining control over their lands. The state of Andhra Pradesh has well laid out laws under the 5th schedule, where there are clear directions that no tribal land can be transferred to non-tribals. Samtha, while mobilizing a people's movement locally, took up a legal battle questioning the legality of the lease as per the land transfer regulations. Let us now see the impact of the Supreme Court judgment of 1997. Samtha first filed a case in the local courts and later in the High Court in 1993 against the government of Andhra Pradesh for leasing tribal lands to private mining companies in the scheduled areas. The High Court dismissed the case, after which Samtha filed a special leave petition in the Supreme Court of India. A 4-year battle led to a historic judgment in July 1997 by a 3-judge bench. The court in its final verdict declared that person would include both natural persons as well as jurisdiction person and constitutional government, and that all lands leased by the government or its agencies to private mining companies, apart from its instrumentalities in the scheduled areas, are null and void. In addition, it also held that transfer of land to the government or its instrumentalities is entrustment of public property, as the aim of the public corporations is in the public interest, and hence such transfers stand upheld. Dear students, the salient features of this judgment are: 1. As per the 73rd Amendment Act 1992, every Gram Sabha shall be competent to safeguard, under clause M2, the power to prevent alienation of land in the scheduled areas and to take appropriate action to restore any unlawful alienation of land of a scheduled tribe. 2. Minerals to be exploited by tribals themselves, either individually or through cooperative societies with the financial assistance of the state. 3. In the absence of total prohibition, the court laid down certain duties and obligations to the lessee as part of the project expenditure. 4. At least 20% of net profits as permanent fund for development needs apart from reforestation and maintenance of ecology. 5. Transfer of land in scheduled area by way of lease to non-tribals, corporation aggregate, etc. stands prohibited to prevent their exploitation in any form. 6. Transfer of mining lease to non-tribals, company, corporation aggregate or partnership firm, etc. is unconstitutional, void and inoperative. State instrumentalities like Andhra Pradesh Mineral Development Corporation stand excluded from this prohibition. 7. Renewal of lease is fresh grant of lease, and therefore any such renewal stands prohibited. 8. In states where there are no acts which provide for total prohibition of mining leases of land in scheduled areas, Committee of Secretaries and State Cabinet subcommittees should be constituted and decision taken thereafter. And 9. Conference of all chief ministers, ministers holding the ministry concerned and Prime Minister and central ministers concerned should take a policy decision for a consistent scheme throughout the country in respect of tribal lands. Let us now summarize this class. Essentially, the 5th schedule is a historic guarantee to indigenous people on the right over the land they live in. However, these prohibitions and restrictions are honoured more in their breach than compliance. 1. Tribals have been displaced from their lands in a massive scale, either for mining or for building dams. 2. They have ended up in the metropolitan slums as unskilled labourers or plain beggars or vagrants. 3. The executives of the state and central governments have been either active participants or mute spectators in the displacement of the tribals from their habitats. 4. There are many occasions when the High Courts and the Supreme Court of India have intervened on behalf of the tribals. 5. Struggle to protect the tribal lands from mining and other encroachments in the name of dams or developments is and will be one of the crucial issues threatening the nation in the coming future. And finally, a determined effort to honour the constitutional provisions regarding the scheduled areas and scheduled tribes will be the only answer. Samtha judgment is a judicial intervention in favour of the constitutional rights of the tribal over their land. Dear students, by now I am sure that you have a clear idea of the issues involved in the protection of tribal lands and the role of Samtha case in highlighting the violations of the rights. Until we meet again, bye.